thing that I'd like to point out about doctrinally how race is dealt with under the South African Act is that historically disadvantaged people are seen to have multiple hats in the economic system. And by that, I mean where some of our colleagues are looking at, I think one of the other papers has to do with market definition and looking at gender, that's thinking about women as consumers, perhaps, thinking about women's capacity to spend money. In South Africa, we don't just look at people of color because it does use race. We don't just look at people of color as consumers, but crucially, part of the South African experiment is about how do we redistribute wealth and redistribute rents to people of color who are not just consumers, but who are business owners and who are employees. And that, for me, engages a completely different economic outcome. If you are saving a woman certain funds that they would have ordinarily paid for a pink tax, that's very different from creating certainty through a moratorium on retrenchments, certainty in employment. That's also very different from creating a supply condition after a merger, ensuring the continuity of supply for HDPs and SMEs downstream or upstream in a market. So the potential and the network effects are different when you're thinking about women as consumers, as employees, and as business owners. And that, for me, is what makes South Africa's framework so absolutely aspirational, is that we look at people of color through those multiple lenses. Now, we do discuss the forestry impact study, which if I go into, I'm going to need to cover quite a bit of ground, and I know that we lost a bit of time at the beginning. So I think what I might do, with my colleagues' permission, is skip the case study and just proceed into point number 2 about purposeful framing. So purposeful framing, one thing that I think we saw in the competition field throughout the 2000s, throughout the early 2010s, was a huge kind of distance from the idea of competition being involved in polycentric, amorphous public interest concerns. Now, us being South Africans, I think we acknowledge that all law is inherently political. So perhaps for us, it was a much easier jump than for other people in different jurisdictions to make the same sort of leap. But what South African case law has been able to provide is legal mechanisms of how to think about weighing these various different amorphous polycentric factors. And in particular, I'm talking about the Massmart case. I'm talking about the merger where Walmart of the United States was taking over Massmart, which held a lot of South African supermarket chains. And there was pushback from public interest interveners who took part in the consideration of the merger. In particular, the minister of the DTIC, as Betty referenced earlier, as well as a union. And their concern was that the merger, as a result of Walmart taking over Massmart, that the Massmart's global supply chain and their procurement potential would lead to a flood of cheap imports, putting pressure on local manufacturing, resulting in job losses all through the value chain in which Massmart has an impact, which is varied because they're quite a diversified group and touch on grocery retail to building and construction and furthermore. And what the judge outlined in that case that I think is absolutely applicable to what we are trying to do here when trying to perhaps balance situations where, for example, the SLPC test, the significant lessening and prevention of competition test, is being weighed against any potential benefits or negatives to the public interest. How does one choose one over the other? There is a means to do it. And South African courts have done this with reference to the fact that, firstly, we look at a merger as not trying to solve all of industrial policy's problems, but looking in fact to the problems that are proximate to the transaction at hand. And I think that has a great narrowing of focus and creates a scope in which intervention is possible. Because of course, naysayers, their big intervention is about, kind of creep and the fact that competition will now become a basket for all problems to be solved. So that's the first point that was made in that case. The second point is that even though you may be dealing with conflicting considerations, this should be grounded in an analysis of the substantiality of the gain and the loss, which means we need to take reference to a proportionality exercise, which means we need to take reference to evidence. It's not enough to just say cheap Asian imports will be brought into the South African markets. It's about what is the evidence of that? What are the procurement chains? What are the HDPs that are currently being supplied by Massmart? Who are those individuals? What is their current supply demand? Asking crucial questions on the evidence and not just taking recourse to theory. And I think South African case law is an excellent example of how such issues that deal with such sensitivities like immutable characteristics around race and gender can be evaluated in a court forum. The third point that was made in that case is about a careful consideration of the remedies. In South Africa, I think the greatest leap that we have made with all of this is that in our merger control, it has introduced a set of remedies and a kind of rent redistribution mechanisms that wouldn't have ordinarily existed. The conditional approval of many mergers on the basis of certain public interest concerns that I'll actually outline a little bit further into exactly what some of those have been, what mechanisms have been used, means that we are able to look at the harm that may be caused by a potential merger, and then the authority is required to assess the appropriateness of the proposed remedy. And that appropriateness has to have a proximal link to the theory of harm. It has to be rational in terms of the size of the rent that's being given. For example, in the Massmart case, there was a development fund that was established. Questions were asked by the CAC, that is our appeal court, of the tribunal's judgment to say, why did you expect 100 million over 500 million? We can't just arbitrarily thumbsuck a number so that firms can just tick public interest when they've undertaken to a condition and move forward. What the South African authorities have tried to do is to actually create effective rent redistribution mechanisms by evaluating the merit of the condition that is imposed in order to address the public interest. Now going to progressionists' participation. And I think we draw a lot on the work of people like Michelle Ma, who speak about stakeholder antitrust, who speak about the fact that antitrust should be about all of the communities that are affected by such behaviors. And so in the South African example, as Betty outlined, we have multiple mechanisms enshrined in the Act to make sure that public interest stakeholders receive notice of mergers and have an opportunity to participate. Again, you'll notice that I'm talking a lot about merger control. That's because our prohibited practices and market conduct public interest sections are only recently brought into force. So we're going to see more of the effect of that moving forward. But as that's the reason for my focus on merger control for the time being. And in particular, we are seeing that women in the South African context have crept into merger control conditions right now, despite the fact that our historically disadvantaged section of the Act only makes reference to race. And in particular, some of the ways in which that's happened is through our employment, public interest consideration. The moratoriums on retrenchments have also sought to protect women. We've got skills funds that have been set up as a public interest remedy, and such skills funds have at times outlined as beneficiaries to those skills funds HDPs. We're talking about supply arrangements and continued supply conditions in merger control that seek to protect the supply arrangements between the instant merging firms and whatever HDP or SME supplier or buyer is on either side of the chain. We're talking investments into the value chain. So if I am a big supplier who is purchasing, has huge purchasing power, There may be a development fund put aside to assist people upstream and skilling them to better provide for, if I am a huge corporate or vertically integrated firm, how to better make their supply match what we need to ensure that we can, start buying higher volumes. And so in the Bala World merger, for example, we have such supplier development programs that preferenced women in particular, named women as a designated group. We've got the Tabong merger, in which there was a divestment of a mining right, and the assessment of a potential purchaser of that divested right would gain further points to become the preferred purchaser if they had women as part of their group. We've got employee share ownership programs that have been a huge thrust of the new public interest consideration that was brought in with the amendment, relating to a greater spread of ownership to workers, and also in particular in the Simba merger, in the Burger King merger, it was mentioned that designated groups of women should not be biased by, for example, issues around maternity leave, in being able to take advantage of the benefits provided in the employee share ownership program. So these are ways in which women are being incorporated into merger control conditions, and we are essentially creating a mechanism for rents to be redistributed going into the future for as long as those conditions exist. I also want to talk about one other very interesting merger control condition that was imposed to deal with issues around employment. Employees were worried about the new acquirer who was going to be changing the location of the business. And those employees wanted not only a relocation allowance to be able to ensure a smooth relocation, but also they wanted their employer to consider a work from home strategy. And what I found very interesting about that was that it touches on issues that, colleagues like Pike have spoken about, the double dividend, that sometimes we can be pursuing another aim and have positive pro-gender benefits, almost has an unintended consequence, a positive externality from what was initially a focus on something else. And in particular, we've had most recently the Burger King case, which was our very first South African case, where even though on the SLPC test, significant prevention and lessening of competition test, the Burger King merger was seen to be unproblematic, it was in fact prohibited by the Competition Commission on the basis that it would have a negative effect on the public interest, and in particular, the greater spread of ownership. The owners of the sellers, or rather the sellers of the business, were a very empowered group. They had a high HDP representation when it comes to race, and also a high HDP representation when it comes to Black women. And the concern of the authority was that the purchase of this business by funds that were located in Mauritius that had no HDP representation, that this would actually result in a backward movement of the target firms' representativity. And based on that alone, they prohibited the merger. And what I found absolutely fascinating about watching this merger move through the enforcement value chain is how much consensus was able to be achieved. Where we are in the process, I can't speak too much to the content of the case as it's still in front of the tribunal. However, public conditions have been released, so I can speak to this. And the fact that despite the prohibition at the commission stage, the merging parties, the commission and the DTIC continued to negotiate to be able to get to a point where they approached the tribunal for a reconsideration of the merger on the basis of agreed conditions that the commission had given input into, that the DTIC had been given input into. And why this is so fascinating for me is I did not expect that the provisions in the Act that cater for participation of our progressionist champions would necessarily lead to such consensus building when it came to coming before the tribunal. It could have been a situation that was more contested, as we saw in the Massmart case, where it was fought all the way up to the CAC. Whereas in this case, the parties came to the table and they negotiated and they found a settlement that was acceptable to the parties. And once it came before the tribunal and there was a hearing and the tribunal considered the issues, they conditionally approved the merger on the basis of some public interest conditions. So all that to say, there is some debunking to be done about businesses' willingness to accommodate issues of public interest. Of course, we see them as being inherently linked to competition concerns as well. But there is some debunking to be done about the willingness of firms to actually abide by rational concerns brought by agencies in a transparent fashion. I'm going to hand over to Betty to discuss the other 2 points on our slide.
I think I'll just briefly touch on the last 2 pillars. Sorry, if you could please go back to the previous slide. So just on the last 2 pillars that we have in that slide, that's going to come up shortly. I think Mpumi has really touched on the ways in which the South African competition authorities have prioritized public interest considerations, especially in enforcement and particularly in relation to mergers. What we also have seen is a prioritization of these considerations in market conduct, and this is market inquiries and the impact studies that have been conducted by the South African competition authorities. And we have looked at the grocery retail market inquiry, which we think is a great example of how you can include inequality considerations in advocacy work of the competition authorities. And this is particularly interesting, this case study, because it reflects how competition issues can directly link to inequality issues, especially in instances where you have economic policies in place that seek to or have sought to exclude certain groups of individuals from meaningfully participate in the economy, for example. And this is, a prime story of the South African economy in relation to the apartheid economic policies. And what we see in this market inquiry is the Commission really trying to understand the ways in which HDPs have been excluded from the higher value generating sectors of the grocery retail inquiry, as well as the upstream. Sorry, in the grocery retail sector, as well in the upstream sector in that segment. And what we see here is ways in which you could do the same in relation to gender. And in as much as we really welcome the outcomes of that grocery retail market inquiry, what we have seen is the fact that the fact that we do not focus directly on gender has meant that we were not able, for example, in that inquiry to dive into the experiences of women in the sector. And what we sort of have seen from research conducted by other scholars in relation to the South African grocery retail market is that there are women in the sector, but they are participating in the lower value generating segments of the sector. So they are mostly in the informal segments of the sector. And just also drawing from what the Commission has identified in the sector is that the informal sector is actually very important when you have households that have low income. They rely heavily on the informal sector because they can get interest-free credit. They can also be able to purchase products from the informal sector at extended hours of the day. So it's a very important sector and competes very directly with the formal sector. And what we saw there in terms of the outcomes of the Commission's inquiry is advocacy measures to try and include HDPs in, the shopping malls where there's, higher foot traffic by, for example, agreeing with, the big retail stores that they would no longer enforce or include in, the lease agreements. provisions which exclude or allow them to determine who can come into a shopping center. So there is really a direct link between competition law and inequality, especially where there are economic policies that result in the exclusion of certain groups. And what's worth highlighting here as well is that, when you do adopt measures that try and, empower parties that are already operating in the market, but in the lower segments or the lower value generating segments of the market, is that when you, take measures that empower them directly, you can have ripple effects. And we see this, for example, in the West African shea butter export sector, where, there has been direct intervention from government to, ensure that these women are able to participate in that segment in a way that they can export their products. So, we see all these issues to be related, and we think that it is important for competition authorities to continue to prioritize public interests in their advocacy measures. And then on the last point, which is really worth highlighting and is reflected by the changes in the South African competition law, is that, all these measures cannot be adopted all at once. This has to be incremental, and incremental, in that it may be possible for, one country to introduce maybe a public interest consideration only in measures, which is sort of where South Africa started, as Mpumi has reflected, and then eventually build the evidence and also just, assess the appetite of the market to, include other provisions that address inequality. And I'll just hand over now to Sonia to sort of reflect on the recommendations to competition agencies in the next slide.
Thanks, Betty. So yes, this is a big question that probably most people in this room are kind of wondering about, what are the key recommendations that competition agencies can kind of take up now, or in the short to medium term, and possibly also from the medium to long term. And we acknowledge, that the implementation of competition policy takes on different forms in different countries, where kind of different levers are used more than others. So, we try to make some of the recommendations listed as generalizable as possible. So first, we see it as vital that, a gender-aware competition policy in the interests of women as owners and key economic participants must prioritize gender in their investigations, such as kind of the impact of mergers and prohibited practices on both key economic sectors for women and on women-owned businesses, as Mpumi mentioned in her contribution. Gender must also, be included in market studies, and very importantly, the intentional collection and disaggregation of gender statistics on women's participation in markets as consumers, as owners of equity, as employers, as employees. This data is really lacking in our investigations, and we kind of, it's important that this data exists because it helps to take stock of and make visible the gendered impacts of anti-competitive practices. Thirdly, prioritize gender and remedies imposed on prohibited practices and mergers in order to make markets accessible to women and to advance the meaningful participation of women in particularly high value generating sectors of the economy, which Betty also spoke about. And in applying the public interest criterion, competition authorities must also take into account the submissions of intervening parties. The submissions and the evidence of the intervening parties must be assessed against those of the merger parties, very important. And lastly, as we've kind of referred to throughout the paper and throughout this presentation, is the importance of collaboration and stakeholder engagement, knowing that, competition authorities and competition policy does not necessarily exist in a vacuum. So thinking about how stakeholders such as government institutions can support the efforts to be more gender inclusive. Next slide, please. I think Betty will start us off on this slide.
You're on mute.
So you can hear me now, right? So in this slide, what we've sort of put together really is just an overview of the future work that is relevant in, building further evidence, because we think that whatever measures are adopted going forward in relation to including gender in competition law and policy need to be informed by evidence. For example, we think that, there's a role for scholars and policymakers to play here in relation to considering, what other broader industrial policies or industrial policy frameworks are relevant for, addressing the gender equity issues we've identified. And this also comes from us recognizing that, competition law does not hold all the solutions, but also acknowledging that there are issues that are impacted directly by competition law and how market structures are. There's a role as well for competition scholars to play to investigate, the possible competition law amendments, South Africa, for example, in this regard, South Africa provides a good example of what can be done in terms of, the amendments that you could include in your competition law. And I think what's also worth noting here is that some countries do have competition laws that don't have a public interest consideration element per se, but have, values that may allow for an inclusion or, consideration of elements such as race and gender. And one example that I could sort of give is Australia, for example, where there is a public benefit test. It's not as clearly defined what the limits of that test is, but, a country like that, for example, could try and use that element to look into all these broader issues. So these are really things that require further investigation. And also, for example, for the South African competition authorities, the work does look slightly different from other authorities in that, we have a public interest consideration that's in place, although it does not expressly include gender. As Mpumi has reflected, there are instances where we have looked at the gendered outcomes of the decisions of the competition authorities. And what we could have start doing here is sort of, looking at the current remedies and see how we can, include gender and empower women in those decisions. And also to build evidence going forward, we could look at, previous decisions and look at the impact that they've had on women in a similar way that we have, looked at, for example, the forestry industry, where we've looked at the impact of previous decisions on HDPs. So it's really also important to highlight that, there are some differences between what South Africa can start doing going forward and what other countries could do. I'm not sure if Mpumi has anything to add on the slide.
Yeah, I think my only addition is in what's been really good to see in the South African example is, as you said, there hasn't been an express reference to women, and yet there has been a probing that I would think is largely part of the tribunal panel's hard work in probing merging parties about how future rents are going to be distributed. And that to me is a key focus going forward. Even if you don't have an explicit provision, I think there can be probing done and questions asked in the moment about where future rents are going. And in the merger context around conditions that are imposed, in particular the rents that are created through those types of conditions, how are those benefits going to be distributed? And what does the lay of the land look like at that moment? Because that's something that we identified was missing from some of the Commission's earlier work, is that there were opportunities where other scholars had highlighted the importance of women in the sector. However, the competition authorities in certain instances didn't even mention the word woman in their studies of how the market was functioning, despite the fact that their investigation was very focused on trying to see the particular challenges of historically disadvantaged persons. And so the importance of emphasizing the group and not just assuming that markets will allocate efficiently or allocate in a fair manner, the importance of actually naming the designated group means that we start to disrupt some social processes that were already in place that serve to invisibilize that particular sector of society and exclude them. So my early, if there's any influential South African policymakers on this call, it would be, we need to continue talking about women in our remedies, in our decisions, and in our reports.
Thanks, Mpumi. So if we could just go to the next slide, which is our last slide. So I mean, in this slide, we sort of try to capture everything we've said and to, give everyone some points to go away with and think about. And just to start off here, I think it's important to highlight that we believe that the ultimate goal for gender inclusive competition law involves setting up a legal framework comparable to that of the South African Competition Act, which is then supported by key industrial policy, strategies, and objectives, because this will ensure that, if there are changes in the leadership of the institutions, whether it's the competition authorities or government, those changes will not impact the objectives that have been put in place and strategies put in place in relation to gender. And in this, we've seen in relation to the South African Competition Act in relation to racial inequality. And we think that is the ultimate goal. I mean, we also recognize and have said in this paper that we don't think that is feasible and possible for everyone. It's not something that everyone can go away and implement after this conversation. But just to give you some ideas of what you could sort of start doing and think about, we think that the first, part of it is scoping. And scoping can really involve assessing the impact of previous enforcement and advocacy decisions on women. And in particular, looking at the barriers that women face in being able to not just participate or enter in the market, but to meaningfully participate in the market, especially the higher value generating sectors of the markets and the economy. I mean, this is work that is also relevant for South Africa as well, because in our research, we were not able to delve into, the lived experiences of women in business and the issues that they face in order to be able to access markets. So this is really a place where most countries can start off. And the scoping section, we think, is very important because then it can inform the ways in which competition authorities and government can think about prioritizing gender in the policy instruments. And just to give an example here for, like the South African amendments to the Competition Act in 2008, in relation to HDPs, were very well informed by the trends that the competition authorities were seeing from, cases that they were investigating. So it shows that doing the scoping work, can enable one, to implement measures that are meaningful and they are direct. So that we think would be, the second phase, which is really, the evidence gathering phase, and it also engaging on, the parties' appetite to engage on outcomes that address gender inequality. As Mpumi has said, I think, especially for practitioners, there may be a tendency to sort of, say these issues are not relevant for competition law, and just, really just stop parties from engaging on these issues, whilst parties may also have social policies that, allow them to, agree to certain conditions relating to inequality issues. So, it's very important to sort of also engage with the parties to assess their appetite for these issues. And ultimately, obviously, is the best way to address gender inequality is, to prioritize it in a way that you include it in competition policy and broader industrial policies. And we think what's important to note is that the competition authorities have a huge role to play to lead this discussion. Obviously, they don't have the last say, but they have an important role in advocating for informed amendments to competition laws. And also government has a huge role to play. I know someone in the comments has also mentioned that the DTIC in South Africa has a master plan that prioritizes gender, for example. That is great. And as we have seen from the examples from Canada in how they prioritize gender, that also shows that, you need government industrial policy leading this discussion as well. I'm not sure if my colleagues have anything to add on this slide. Okay, I think that's it from us, and thank you everyone for listening.
Thank you very much, and that was an absolutely fascinating presentation. We very much appreciate it, especially as it across and it brings together so many of the points that have been raised in the other projects, which in itself is very valuable to us to have one project that's sort of pulling it all together. The researchers are ready to take any questions that are specific to their project, if you have them, before we move on to Bill. So if you want to raise your hand or let me know if you have a question or a comment specific to the project, or if you're ready to move on to Bill. Okay, so I'm not seeing any hands, which I think is an indication of how comprehensive you were. And so let me now turn the floor over to Bill. Bill, will you be showing your slides, or would you like Nestle to show your slides?
If Nestle could please do that, and if she could simply go directly to the slide with recommendations. There are 3 recommendations. If we go to those, we'll focus specifically on those. Lynn, I'm so grateful to you and the Secretariat at OECD for the opportunity to participate. I want to thank your colleague at the time, Chris Pike, who also played a key role in doing this. It's a tribute to the farsightedness of the Secretariat to make this a key concern. And I'm also most grateful to the Competition Bureau of Canada, which in this and so many other matters has been a leader for all of us in the world in thinking about how to do work in this field. I want to take up the challenge that Ellen mentioned in her opening comments, which is how one goes about taking the long journey between the policy aspiration and the realization of its aims in practice. And I want to focus on 3 suggestions about how to do that. That is 3 ways that agencies can go about this. And with the guidance of the Secretariat and a number of other observers, I've tried to single out 3 feasible practical steps that agencies can take, steps that don't involve the equivalent of the Manhattan Project, that fit in many respects within things they're familiar with doing already, but would take us a good ways towards realizing the ambitions of the Gender Project. The first recommendation deals with representation and decision-making. And the intuition here is that an agency that has a full representation based on gender throughout its decision-making processes and within its key units is going to be more attuned to the kinds of concerns that motivated the entire undertaking on the part of the OECD. This requires an appreciation of what an agency has done through its appointments and what government has done by putting leadership at the head of the agency and in key subsidiary places. This is examining who heads the agency, who serves on crucial governing boards, who serves on internal committees that decide which projects get a green light and proceed with an application of the agency's resources, who, in other words, are the key decision makers. And a simple step that an agency can take here is to do a chronological depth chart that shows who has run these key capacities over time. Go back to your origin, take the key operational decision-making units, take the head of the agency and the board, and simply identify who these people are. I would suggest a rough test like this. If your agency or institution is 20 or more years old, and only men have served in these crucial positions, and let's focus on head of the agency. If you are 20 or more years old and the only leaders of your agency have been men, you have a gender problem. And you cannot excuse the performance by saying it's hard, it's difficult, the talent base isn't there. These are all pathetic, threadbare excuses. And a number of comments that I've received from others who've looked at earlier drafts of the work is that this applies to international organizations. That is, if you go back a period of 20 years and you have only had men running key positions related to competition policy, be it an international organization or a professional society, and you've had no women occupying that crucial leadership post, you have a gender problem. And again, the answer to that is not to say it's too hard to do. I think one thing that international organizations and individual jurisdictions could do to highlight this is to point to the talent that is available. I don't see this as an exercise in simply achieving greater gender representation for its own sake. I see this as a desperately important task that serves to bring the best talent that a jurisdiction has into the field. And that if you are not drawing upon this remarkable emerging talent pool, you're missing a good game. I think one thing that would be helpful to do is to have programs that focus on a number of women who've been pioneers in the field. How many people on this call know Anna Fernelchik? How many of you recognize the name Beatrice Boza? How many of you, indeed, in or outside of North America, know who Ann Bingaman was? Ann Bingaman was the first head of the Antitrust Division of the Department of Justice. Ann Bingaman, more than any other human being, created the modern institution that we refer to as antitrust leniency. And those of you who as enforcement agencies or as practitioners benefit from the operation of leniency programs, every night you should pray to whatever God you fear and thank the creation of Ann Bingaman, because Ann Bingaman made it possible to do this. And it's not only Ann or Anna or Beatrice. If you go through the history of appointments to agencies, you see this exceptional talent that's been brought into the field. And if your agency or institution is not drawing on it, you're falling behind. And you're not simply failing to account for larger questions of equality, you're damaging your own performance. So one starting point I would say is, who's running the show? Who runs your key committees? Who runs your key decision-making processes? Formulate that chronology over time by category, by area, and study it carefully. And ask yourself, if these are all men, is this the best you can do? And I do think a key function that international organizations, professional societies, and others can do is draw our attention to how agencies that have drawn from this talent pool have prospered. And it wouldn't be a bad idea to have the periodic series of seminars and programs that bring what I refer to as the modern founders to the fore, not just to celebrate their experiences, but to remind us of what you're going to miss if you don't draw upon this pool of talent. So, step one, necessary but not sufficient, is representation. The second step is to learn from your own past experience. And here I'm going to echo a number of observations that our three colleagues from South Africa have mentioned. I took a look at the decision-making of a number of agencies, but intensely looked at the decision-making of the agency I worked for a number of years, the US Federal Trade Commission, taking its budget decisions back to 1960 and its resource allocation and project selections over that period of time. And I did it as part of a larger inquiry that I think every agency should make for itself, which is to ask, how did you spend your money? Why did you do it? Why did you make those choices? And who benefited from your program? I'd suggest that these are questions that an agency ought to ask anyway, ought to have a good answer to. So what I'm going to suggest now does not require a great deal of additional effort, but I think is very informative. And the key thing is to examine your budget decisions and your priority and project selection carefully. And if you do so, I think you'll find a number of respects in which you can shape a program that's not a major deviation from what you do already, but is much more sensitive to the considerations that my colleagues today and the other researchers have mentioned. Part of what I think you'll find is that a healthy practice of an agency, that was certainly the case of the Federal Trade Commission, was to focus on core sectors that had unusual benefits for historically disadvantaged groups. And I'm not limiting my observations to women who had less access to the marketplace, had more barriers placed in their path in making effective choices as consumers, much less serving as owners of businesses. The FTC's program over this long span of time is focused overwhelmingly on the following sectors: healthcare, food, energy, transport, with others at different times being more important. What you can see when you look more granularly at specific projects, and I had the chance to look at lots of internal FTC decision-making documents, is that you see a striking number of cases in which gender, in fact, was a major consideration, where reference to gender or to other factors that have resulted in historical exclusion came to mind as a basis for promoting the case. What I'm suggesting is that you can examine your past experience to find that there are lots of things you have done that are entirely consistent with the approach that we've been discussing today and in the other work, that you can tell case handlers and managers, I'm not asking you to do something that's a dramatic departure from past practice. I'm asking you to focus on, study examples that you've used before and extend them. Indeed, in many instances, I want to suggest that in a number of cases, these considerations have had a force in shaping project selection and prioritization. And what the project in which we've engaged would do is to make more evident some of the decisions that have been shrouded in the past. That agencies, I'm going to suggest to you in some ways, have considered these as important factors. And what I'm proposing is that you can bring them forward and to make more evident and transparent the decisions themselves. So, yes.
Bill, I'm afraid I've done a terrible job as a moderator because I kept South Africa speaking long because I found them absolutely fascinating. So I want to leave a little bit of time for questions. So I'm going to ask if you could speak either quickly or just bear in mind that we'd like to be able to take
speak very, very quickly, and so you can get everything, Lynn, done very quickly. Or I'll use
and it's just my fault for badly moderating, but I found
a last observation. The third is to work to promote market access. Access that enables women, and to the extent that we looked at other categories of those who've suffered from disadvantage. Limited access as workers, as owners in the market. To the extent that you remove artificial barriers to market participation and you use your advocacy, case selection, and research programs to do this, you have created the basis for much greater economic progress and the basis for a society that has greater confidence in its civic organizations and its private actors as being legitimate and serving the broader interests of society as a whole. So the third specific recommendation is you focus on resource allocation that promotes market access, and you eliminate unnecessary barriers. And who keeps score on all this? This is where the international organizations can benchmark agencies to see how they're doing over time, setting a baseline, collecting data, and reviewing their performance. Thank you, Lynn.
So I was sorry to cut you off. And again, I apologize for the bad moderating I did by not keeping a better eye on time, but take that as being a reflection of how fascinating I've found the presentations, and I hope you have too. So we do have time for some questions and comments. And as I said, they are really important to us to get your feedback on what you're thinking and how you're absorbing what's been put on the table in front of you. So they're ready for your questions. They're ready for your comments. Who's going to go first? No. One of the things for me is this importance of ex post evaluation. Both of you have mentioned this. Both groups have mentioned the importance of evaluating, whether it's decisions, evaluating the remedies, evaluating decisions within the agency as well. So it seems to me that stock taking and ex post evaluation is the lowest hanging fruit. It's a place that agencies can start to see where they need to work. And that's probably my first observation of seeing what's been done. The second is, to me, is the important use of remedies, how remedies can play a very, very key role in this. But I'm curious, you mentioned about creep. And this is one of the arguments that we've been seeing too, is that if we start to include gender, but what about aging population? What about poverty? The what about da-da-da? And so how would you counter that argument if people say, oh, but this is just the start, it's creep, as you mentioned it? And I'm just curious from South Africa now to go over to Bill, how you would respond to that.
Just a quick thought, Lynn, which is that one thing I have in my paper, I have the list of policy focal points that OECD roundtables over the last 20 years have urged upon agencies, and it's a long list, and it says do lots of things. I think an answer to it is to say there are categories of project selection choices you can make that serve an extraordinary array of interests. I think you can address lots of concerns, and looking again at where you spend your money, and ask yourself what has the greatest social benefit. And as part of social benefit, you identify specific interests, particularly for groups that historically have been put to the margin, and to see that as an important objective. I think if you do that, you'll pick up lots of areas where single cases serve lots of purposes. But the second that I believe in, and this is not new to OECD, this is the toolkit on regulatory controls. This is the toolkit that tells governments serve legitimate regulatory functions, but do it at the lowest possible cost of competition. Remove artificial barriers that keep talent, wherever it is, from reaching its fullest possible expression. And I have a lot of confidence that a jurisdiction that does that is going to hit lots of the objectives that show up on the expanding list of aims that are urged upon competition systems, because you don't know unless you give them a chance to perform exactly what they can do to solve problems. So I see a big answer to be right in the core of what the OECD has been doing for the last 10 years with the toolkit. Open access, see who shows up, and be amazed and surprised at what those people can do.
Betty, Mpumi, do you have anything to add?
Yes, I mean, what I think most of those proponents who are concerned about creep often have hidden as an assumption in their question is the idea that markets are not allocating unfairly anyway. So to me, the real question is, what does your society look like? And that'll tell you how far and who to reach out to. In the South African example, we have a great document to cling to. We've got our constitution, which serves as that generalized document that has as an impetus the various vulnerable groups that need to be protected. But in a society where you don't have something like that, all you need to do is run the numbers and ask yourself, who are those people who are not able to contribute meaningfully to our economies? And why is that the case? So this could potentially be, and I can see arguments saying, well, if you look at disability, for example, maybe you might find that there's a whole lot of people to work within that scope, and so on and so forth. But when we are going through the times that we are, of the levels of inequalities that we're seeing now, I think the first question is to say who's at the very bottom of that inequality pool, and who's not able to participate in the economy, and then ask why.
Right. Lynn, if I can just follow on that wonderful point, which is, I think it's entirely fair to say we do have priorities. Let's start with those in the weakest position and work up. And in the many times I appeared before legislative committees who'd asked me to do 1,001 things, I would say, let's pick with the most important, the important concerns.
Does anybody any of our participants have anything to add to that? I noticed that many of you come from, you all come from a wide range of different backgrounds. I can see many different competition authorities represented here from around the world. So I'm curious to get some other perspectives on this issue. No, you're overwhelmed by the expertise that has come at you. My other point too was how to hardwire this, because it's one thing to have a champions within the competition authority who are promoting it, but how do we hardwire it? And South Africa gave us one example, but I'm wondering if we cannot go to industrial policy, if we cannot change the competition law, what other ways could it be hardwired?
Lynn, can I offer a quick thought? I think that one of the major ways to ensure that this is not ephemeral, but durable, is the continued attention of the international networks themselves. That is to bring the pressure and the encouragement of international organizations to bear on the topic. That is, you might not devote every session of the meetings to this topic, but you wouldn't want to go a year without having it on the agenda. You would not want to go a year without seeing it represented in the work plans of the regional centers and other efforts that OECD carries out. And you'd want that to be front and center, I think, on the agendas of the other networks and the professional societies and academic societies that join up the work. That is to sustain momentum by bringing attention to it. And to ask, because you have the ability to benchmark institutions, to ask them, what did you do in the last 12 months on this? Show us your concrete accomplishments and show us what you're doing. Bring forward your examples that identify this. I think your intuition of your question is exactly right, Lynn. If there's no sustained effort, pressure, encouragement, no, it can be sidelined easily.
I just want to turn to Odie. I think I pronounced your name correctly, because who made an interesting comment in the chat, almost about the gamification of this issue.
Yeah, no, certainly. Thanks very much, Lynn. Thanks for the stunning session. It's really mind-blowing. And just for putting reference or for putting resources into this question, it's really important. Yeah, the point that I'm just making is that we see a lot of emphasis on women in this and women in that. And sometimes I feel that those things aren't really doing the thing. What we are looking for is much more integration. Otherwise, it's also becoming a kind of a second-rated group. Are the women in this and the women in that? So that was just an observation. The other issue that you've mentioned was the issue regarding impact assessments. And I think what is important there is to also be very sure about the methodology and to know exactly what you are measuring. Based on an analysis that I did on impact assessments done in the SA context, of the initial impact assessments before it was legalized, was that any kind of result is considered to be positive. So I think one should also be careful of that. One should be really critical about the way that you conduct your impact assessments and be willing to learn from the real data, and not only think that you will get more mileage if you believe that your responses or your past experience is necessarily correct. Thanks, Lynn.
Great, thank you. I think we're now being
at the bit. Can I
respond to that? Yeah, please do. And then we'll just to the main room, unfortunately, but go ahead.
Okay, I just want to make 2 points. I mean, Odi, Thank you so much for your interventions. The first one is a complex thing about Bill's point that I want to engage with a little bit. And I think some of these points were even raised at our last session. And that was the question of, representativity as kind of a quota tick box exercise versus a fully more integrated and actually producing a disturbance of the systems that keep the status quo. And I just want to put out there the dangers of surrogating that work just to representativity. And I know, Bill, he said it's necessary but not sufficient. And I would agree with that statement because, in the South African context, our parliament is possibly the most representative when it comes to women's issues in the world, if not the continent. And unfortunately, our society doesn't reflect that at all, in the sense that we are the most dangerous country for women to be alive in today. So representativity cannot be surrogated. And I think it's kind of touching on what Werdy's saying when we're talking about women in antitrust. It's almost become an easy way to not engage with the systems that put women on the outside. And this is the point that I was making at the beginning, which is remembering that it's not about creating this designated group that we see as a fragile little egg that we're trying to protect out of the goodness and charity of our hearts. No, it's because there are systems that make sure that women are not part of this, are not able to meaningfully participate. And it's there that we should be emphasizing so much of our energy, and not just why are women in antitrust. We're so happy to have so many women. Let's ask the question, why aren't we having more women? So again, it's coming back to the system, not the person, the system that keeps them in place.
Hey, Lynn, can I come in on this?
Absolutely.
I thought I said before pretty directly that it's about talent. That is, if you want to have a better agency, if you want to be more effective, you have to go where the talent is. And if you are not drawing upon all the pools of talent in your society, you fall behind. So it's not to help a fragile group. It's not to help a group just for the sake of doing it. The point of looking at the experience of women who have made enormous contributions, have changed the world we live in. That's the reason you bring in the broader team and you look for the talent. I'd put it this way, simply stated, if you are not looking across your society for talent wherever it is, whoever it has it, you're not running a good institution and you will ultimately fail. It's all about talent.
Right. Thank you, Bill. I agree with you. Is there any last comments or statements before we've got 2 minutes before we have to go back into the main room? Anybody else? Last comments? Oh, Ellen, please.
Hey everyone, thank you so much for this. And part of the reason I haven't asked any questions is because my brain is just whirring. So there's probably smoke coming out of my ears. I'm wondering about culture change within agencies and organizations, and what are the building blocks for culture change in this area? Because in order to, I think to make things sustainable, there does have to be a culture change. And I'm just wondering what you believe, though, what are the elements of that? And where there is resistance, how can that be overcome?
Okay, you've got 1 minute to reply because we have to get back to the main room, I'm afraid. Who would like to reply?
My simple answer is one way to change culture is to give people vivid examples of how doing things a different way has changed the world. And do you want to be trapped in a path that takes you backward, or do you want to go ahead and put it that way and say, here are the examples of how to do it. You can do it. You're better off for it. It's not something you have to do. It's something you want to do. I think that changes culture by showing the link between results and a different way.
South Africa, 30 seconds.
Yeah, I'd add in there to say that this goes to the talent pool, and it goes to who sits on the table where decisions are made, where, you know, competition issues are being considered and how you define markets, and, you know, what role those people have when they sit on the table. I think there's been quite a lot of work that's been done by social sciences researchers on how you can't just have a table that has representation, but the representation, you know, cannot inform the decisions that are made in those tables. So if you have the pool of talent and they can have a say in the decisions and the outcomes of the processes that are being considered, then, you know, that will create the culture change. And that culture change is important, especially for competition authorities, in how they view markets and how they address certain issues. I mean, we've seen a bit of research in the US, for example, about, you know, Black women's hair products. You know, that is a market that people who are not women of color will not understand. But if you have women of color in a table that is assessing a merger relating to those types of products, you know, the views and insights that you're going to get are completely different. So you do need to have representation, and the people that you have as representatives need to have a say as well.
Okay, I'm afraid we're going to have to end here. I encourage you to continue the conversation on our LinkedIn group, especially as I could not get to all of your questions. And just as it warms up, it's always this way. So thank you very much, everybody. Sonia, please post that on the LinkedIn group to get the conversation going over there. You click on the bottom right, you'll see leave room, and that's going to automatically take you back to the main room where we're going to have a wrap up.